I want you to try a little visualization exercise with me for a second. Just close your eyes if you can. Picture a courtroom. What do you see?
Oh, wood paneling.
Exactly. Wood paneling, high ceilings, maybe little dust motes floating in a shaft of light. And right in the center, sitting up high, is a judge.
Right.
Probably wearing a robe, looking stern, maybe banging a gavel to bring order to the chaos. It's a very human image, isn't it? It feels heavy. It feels momentous.
Yeah, it's the image we've cultivated for centuries. The human arbiter of truth. You know, the Solomon figure.
Right. But here is why we are here today. That image is rapidly becoming a facade.
It really is.
It's a nostalgic skin stretched over a reality that is changing so fast most of us haven't even noticed. Because behind that wooden bench and increasingly on the screens in front of those judges, something else is taking the wheel. We have this pop culture idea of robot judges, you know, the Terminator sitting in the chair. But the reality is much more subtle, much quieter, and honestly, a lot more pervasive.
It is. I mean, it's not an android holding a gavel. It's the invisible code that is scanning the files before the judge even walks in the room. It's the algorithm that drafts the sentence. It's the software that flashes a red warning light if the judge decides to be lenient when the math says they should be harsh.
That is the part that really got me in the research, the warning light.
Yeah.
So today on the deep dive, we are looking at how artificial intelligence is rewiring courtrooms around the world. We're talking about smart courts. And to get us hooked, I want to throw a specific example at you that I found in our stack. In Brazil, the Supreme Court has an AI named Victor.
Named after Victor Hugo, the author of Les Miserables, which implies a certain poetic justice.
A literary touch for a digital machine.
Yeah.
But get this. Victor has read more case dockets than any human could read in 1,000 lifetimes. It was trained on something like 3 million court documents. Or take the 206 system in Shanghai. It's practically a backseat driver for the judge. If a judge misses a piece of evidence, or if the chain of custody looks shaky, the system intervenes.
Right. It essentially peer reviews the human in real time. It creates a dynamic where the computer is the supervisor and the judge is the operator.
Which is a complete inversion to how we think the law works.
Yeah.
So what is our mission here? We have a massive stack today, reports from the EU Council, deep research on Chinese judicial reforms, surveys of U.S. judges, academic papers on 28 advanced democracies. We aren't just here to say, look, cool tech.
No, absolutely not. The mission today for you listening is to move past the wow factor and get into the why and the so what. We need to understand the drivers of this adoption. We need to look at the big pillars identified in the research, how this tech improved access for the public, how it handles the crushing weight of evidence, how it spots bias or creates it, how it catches misconduct, how it drives efficiency, and finally, how it enforces consistency.
And we have to make sure we distinguish between the Wild West of experimentation and what's happening in common law systems like the US or UK, because the rules there are very different.
They are. The legal culture dictates the technology, not the other way around.
Okay, let's unpack this. I want to start with the drivers. Why is this happening now? Because if you ask anyone on the street, they'll say efficiency. The courts are slow. Lawyers are expensive, lawsuits take forever, so we need computers to speed it up. Case closed.
You would think so. And don't get me wrong, efficiency is the headline. Everyone wants a faster trial. But if you actually dig into the research, specifically that study we have titled Adoption of Artificial Intelligence in the Judiciary, a comparison of 28 advanced democracies, it turns out that efficiency gains alone do not explain why countries go down this road.
Wait, really? Because I assumed it was just about clearing the backlog. That seems like the only reason a government does anything.
It's the assumption. But this study looked at 28 countries over a period of years, and they found that the mere promise of making things faster wasn't the statistically significant deciding factor. There were deeper, more ideological drivers at play.
Ideological. In court software.
Yes. And this is where it gets surprising. They found a significant correlation with the political leaning of the government. Left-leaning governments were far more likely to initiate AI judicial projects than right-leaning ones. In their data set, they found 17 projects initiated by left-leaning governments versus only 6 by right-leaning ones.
Okay, stop. I have to challenge that. That feels completely counterintuitive. Usually when we talk about right-leaning or conservative politics, we talk about fiscal conservatism, cutting waste, draining the swamp, running the government like a business. Wouldn't an automated judge be the ultimate cost-cutting measure? Why aren't conservative governments all over this?
That's exactly the question the researchers posed. And just as a reminder to listener, we are just reporting on the data from the study here, not endorsing any political viewpoint. But the answer reveals a fundamental difference in how these ideologies view the role of the state.
How so?
Think about the motivation. If your role is fiscal conservatism, simply cutting the budget, AI is actually a terrible bet in the short term. It requires massive upfront investment. You have to build server farms, you have to digitize millions of paper records, you have to hire data scientists who cost a lot more than clerks. It's an expensive infrastructure project.
So it's not a quick fix for the budget.
No. But if your ideology leans left, generally speaking, you often aim to expand state services. You view the justice system not just as a mechanism for punishment or contract enforcement, but as a public utility, like water or electricity. You believe the state has a duty to be responsive to the citizen.
So the left sees AI as a way to scale the service rather than just automate the worker.
Precisely. The study suggests these governments are driven by a desire to expand the reach of the state. They want to ensure that a citizen in a rural village or someone who can't take time off work has the same access to legal recourse as a CEO in the capital. That requires a technocratic expansion building digital bridges. It's less about law and order efficiency and more about welfare state accessibility.
That actually makes a lot of sense when you frame it that way. It's about state capacity.
And that leads to the second driver, which is purely geopolitical, peer pressure, or what the academics call diffusion effects.
Peer pressure, like, oh, France has a robot lawyer, so we need one too, or we look lame.
Essentially, yes. Countries copy their neighbors. The study found a strong correlation where if a neighboring country has high e-government adoption, a nation is much more likely to adopt judicial AI. It's a signal of sophistication. If you are a country and your courts are still running on fax machines and paper piles while your neighbor has a fully digitized AI-assisted docket, you look like a low-capacity state.
It's keeping up with the Joneses, but the Joneses are the European Union.
Exactly. You don't want to be the jurisdiction that looks stuck in the 19th century when the global economy is moving into the 21st. Foreign investors get nervous if they think your courts are slow and archaic.
So we have political ideology and neighborly competition driving this, but we can't ignore the human element here. You mentioned the justice gap earlier. Is that just a fancy way of saying lawyers are too expensive?
It is the core of the humanitarian argument for AI. Globally, legal aid is perpetually underfunded. There is a massive chasm between having a legal problem, say a landlord illegally keeping your deposit, or a dispute over a small debt and actually getting it resolved. For most people, hiring a lawyer at $300 or $500 an hour is simply impossible.
It's the too poor to sue, too rich for a legal aid trap.
Right. So the courts become the playground of the wealthy or the corporations. This is where AI is seen as a bridge. We see this term in the sources, justice as a service.
Which sounds a bit like a Silicon Valley startup pitch. Uber for law.
It does, but strip away the buzzwords, and it's about democratization. If an app can help you resolve a dispute for $50 that completely changes who gets access to justice, it bypasses the traditional gatekeepers.
Which brings us perfectly to improving access to justice. Let's talk about the front door. Because for most people, the legal system is a terrifying maze. I've tried to read terms of service agreements. My eyes just glaze over. I can't imagine trying to read a civil procedure code.
And you aren't alone. That front door problem is exactly what specific AI programs are targeting. In places like the EU and specifically in Victoria, Australia, they are deploying chatbots and virtual assistants. But I want to be clear, these aren't just customer service bots that reset your password.
So it's not just a generic "how can I help you" prompt.
No, these are diagnostic tools. Think of it like a triage nurse at a hospital. When you walk into an ER, the nurse doesn't perform surgery. She asks, where does it hurt? How long has it hurt? On a scale of 1 to 10. The AI does this for legal issues.
Give me an example of how that looks for the user.
So a user logs onto a Justice Connect style portal. They might type, my boss fired me because I was sick. The AI parses that. It asks follow-up questions. Were you on authorized leave? Do you have a contract? How long have you worked there?
It's structuring the messy human story into legal categories.
Exactly. It identifies if there is a valid legal claim, like unfair dismissal. Then it helps the user fill out the forms. It guides them through the procedural maze. It lowers the barrier to entry significantly.
And I saw something in the European Court of Justice notes about language access. This must be huge for a multilingual place like Europe.
It's critical. The European Court of Justice is piloting strategies to use AI for automatic subtitles in hearings, but even more futuristically, they are looking at AI avatars to give briefings.
An avatar. Like a video game character.
A photorealistic digital human. Imagine you are a citizen in a country where you don't speak the dominant legal language perfectly. Maybe you're an immigrant in Germany. An AI avatar could explain the court's ruling or the procedure you need to follow in your native tongue instantly with perfect legal accuracy.
That makes a court feel less like an alien fortress. But we have to address the elephant in the room regarding self-represented litigants. These are people using AI to be their own lawyers.
This is where the technology becomes a double-edged sword. On one hand, you have the concept of be a TNA best alternative to a negotiated agreement. AI tools can help people understand their position, format their documents, and essentially lawyer up without a lawyer. It levels the playing field against a big corporation.
But, and there is a big but here, we've all heard the horror stories. The hallucination problem.
Yes. This is the fear that keeps judges awake at night.
The idea that someone uses a generic large language model like a basic ChatGPT to write their legal brief, and the AI just makes up cases. Oh, yes. In the case of Smith versus the Moon, it was decided, and it's total nonsense.
It has happened. There are documented cases in the U.S. where lawyers, actual lawyers, used ChatGPT to write briefs and didn't check the citations. The judge looked them up and they didn't exist.
So if lawyers are making that mistake, imagine a regular person doing it.
Exactly. And the sources regarding the U.S. judiciary highlight this risk. If you have users submitting hallucinated briefs, it clogs the system and undermines the truth. But the experts in our source material counter this by making a vital distinction. We have to distinguish between prototypes and production-ready apps.
What's the difference exactly?
A raw LLM is a prototype. It's a creative writing tool. A production-ready legal app is grounded. It has guardrails. It is connected to a verified database of real laws and real cases using a technique called RAG retrieval augmented generation.
So it can write the sentence, but it can only pull the facts from a trusted library.
Correct. The argument is that we shouldn't ban AI because the cheap versions hallucinate. We need to invest the resources to build the production-ready versions that are safe for the public to use.
It's like saying don't ban cars because some cars have bad brakes, build cars with better brakes.
Precisely. And we see this working in online dispute resolution, or ODR. The Netherlands has been a pioneer here. They use what are effectively robot judges for debt disputes and landlord-tenant issues.
How does that work? You just go to a website?
Yes. Log in, you upload your lease, you upload the emails where your landlord said he'd fix the sink and didn't.
Mm-hmm.
The landlord logs in and uploads his side. The algorithm looks at the law, looks at the facts, and issues a resolution.
No courtroom. No yelling objection.
None. It's asynchronous, it's fast, and for clear-cut cases, it works. It clears the docket for the messy human stuff.
Okay, so that's the front door, helping people get in. Now I want to walk past the reception desk. I want to go into the back offices, the rooms without windows, where the clerks are buried under mountains of paper, because this is the heavy lifting.
This is the engine room. And honestly, while we debate the ethics of robot judges, the robot clerks are already running the show. The efficiency gains here are undeniable.
Let's start with transcription. It sounds boring, but it's huge.
It is. In China, they are using the iFlyText speech recognition system in over 4,000 courtrooms.
4,000.
Yes. And the stat in the report is staggering. It has reduced average trial times by 30%.
Just by typing faster.
Think about the friction in a traditional court. The clerk has to type everything said. The judge often has to say, pause, let the record catch up. Witnesses mumble. With iFlyText, the system transcribes in real time, distinguishes between speakers, even with different accents, and creates an instant text record. The judge can click a line of text and hear the audio.
So it turns the trial into a searchable database instantly.
Exactly. And the EU is doing parallel work. It frees up the humans to actually think about the case rather than focusing on typing.
But transcription is just capturing words.
Yeah.
Let's talk about capturing meaning. Let's go back to Victor in Brazil. You said it was trained on 3 million documents. How does it actually read?
This is a great example of document management on steroids.
Yeah.
The Brazilian Supreme Court was drowning. They receive an absurd number of appeals, tens of thousands a year. It was physically impossible for the judges to review them all to see if they were even eligible for the court.
So they built Victor to be the gatekeeper.
Yes. Victor uses OCR optical character recognition to read the PDFs and images, but then it uses natural language processing, or NLP, to understand the structure. It breaks the document down. It finds the law, the argument, the facts.
So it's not just seeing words, it's seeing the architecture of the legal argument.
Correct. And its main job is to identify general repercussion. In Brazil, the Supreme Court only wants to hear cases that matter for the whole country, not just a petty dispute between two neighbors. Victor classifies the applications. It says, this one is a constitutional issue, send it to the judge. This one is a minor debt issue, reject it.
It's filtering the noise so the signal can get through.
And it does it with incredible speed. What used to take clerks 45 minutes per document takes Victor 5 seconds.
5 seconds. That is transformative. But identifying a document is one thing, checking evidence is another. This is where we get to the 206 system in Shanghai again.
This is the evidence analysis piece, and this is technically more complex. In a criminal case, you might have hundreds of pieces of evidence, witness statements, DNA reports, interrogation logs. The 206 system is designed to validate that evidence.
We keep saying validate. How does a computer know if a piece of evidence is legal? It's not like a photo of a knife has a barcode on it.
That is the magic of combining NLP with knowledge graphs. The 206 system doesn't just look at the file. It extracts data points. Let's say you have a police interrogation transcript.
Okay.
The system scans the transcript. It knows, based on the criminal procedure law programmed into it, that an interrogation requires 2 officers to be present to be legal. It scans the metadata and the text for the names of the officers.
And if it only finds one name?
It flags a procedural flaw.
Yeah.
It tells the judge this evidence might be inadmissible because the interrogation protocol was violated.
Wow, so it's not judging the content of the confession, it's auditing the procedure of the police work.
Exactly. It's performing a validity check that a tired human judge might miss after reading 500 pages. It catches the technicalities.
That sounds incredibly useful for avoiding miscarriages of justice based on sloppy police work.
It is. And in the source material regarding OLGA, they mention using this for complex or voluminous documentary material like the Dieselgate emissions scandal.
Oh, right, the Volkswagen thing?
Imagine a lawsuit with thousands of claimants, millions of pages of technical emissions data. No human team can cross-reference all of that effectively. AI can analyze those volumes, spot the patterns. Hey, all these cars produced in this factory on this date have the same anomaly, and classify the cases. It makes mass litigation manageable.
Okay, so we have speed, we have organization, we have procedural auditing. But now we have to walk up the steps to the bench. We are entering consistency and deviation analysis. And I'll be honest, this is where the research started to give me the creeps.
This is where we move from AI as a clerk to AI as a guardian of consistency. And it touches on a core value of law, treating similar cases similarly.
Which sounds good on paper. If I steal a loaf of bread, I should get the same punishment as the guy next to me who stole a loaf of bread.
Ideally, yes. That is the concept of predictive justice. In China, they have a system called FITS. It uses first-order logic and deep learning to predict potential outcomes based on similar past cases.
It predicts what the judgment should be.
Based on historical data, yes. It says in 95% of cases like this, the sentence was 6 months. And this leads to deviation analysis. This is happening in courts like the Jiangsu High People's Court. The system calculates a deviance ratio.
A deviance ratio. Even the name sounds Orwellian.
It's highly technical, but the implication is profound. The system effectively grades the judge on how close their ruling is to the historical average.
Hold on. Let's pause there because that sounds terrifyingly bureaucratic. You're telling me that a human judge, someone who went to law school, passed the bar, was appointed, is getting a report card from a machine saying you are 15% too lenient today.
It's not just a report card, it's an active intervention. If the judge tries to issue a ruling that falls significantly outside the AI's predicted parameters, the system triggers a warning.
A pop-up window. Are you sure you want to do this?
Essentially, it demands a written explanation. Why are you deviating from the norm? The goal, stated by the authorities, is to prevent corruption. If a judge suddenly gives a very light sentence to a wealthy defendant for a crime that usually carries a heavy sentence, the system flags it. It creates an audit trail.
Okay. I see the anti-corruption angle, but play that out for me. I'm a judge. I have a defendant in front of me, let's say a young kid who stole a car, but I see extenuating circumstances. Maybe he was coerced. The AI looks at car theft and says, 3 years prison. I want to give probation.
The system flashes a warning. It requires you to type out a justification for that probation. Now, technically, you can still do it. You have the authority.
But do I want to? If I know that typing that justification puts me on a watch list for an audit?
And there is the chilling effect. The study refers to this as algorithmic authoritarianism or automation bias. You aren't being forced by a gun. You're being nudged by the path of least resistance.
It's a compliance trap.
Aha.
I'll just agree with the machine so I can go to lunch and not get flagged by the oversight committee.
Exactly. You lose the human element of mercy or nuance because the machine doesn't understand why this specific case might deserve a different outcome. It only knows the math of the past.
And if we only follow the math of the past, we get stuck there. Which brings up that other concept from the outline, contra LEX.
Yes. This is a fascinating counterpoint to the deviation analysis. Most AI looks for the majority opinion. What do most judges do? But contra LEX is a framework that analyzes dissenting opinions too.
The judges who disagreed.
Right. Because in law, the dissenting opinion is often the seed of the future.
Oh, that's a beautiful way to put it.
Think about civil rights cases. The dissent in the 1890s regarding segregation becomes the majority opinion in the 1950s. If we only train AI on the majority on the status quo, the law becomes stagnant or crystallized. It locks us in the past forever. Contra LEX tries to prevent that by surfacing those dissenting views, ensuring the law can still evolve.
That is a crucial point. If we just automate the past, we never get a different future. And speaking of the past, let's talk about bias, because the past wasn't always fair. Let's look at bias misconduct and judicial independence.
This is the classic debate. The hungry judge versus the biased algorithm.
I love the hungry judge study. It's the one where they found judges are harsher right before lunch, right?
Yes. The study suggested that rulings granting parole dropped to near zero right before a meal break and spiked back up to 65% immediately after.
Because they were hangry?
Literally. They are tired, their glucose is low, and they default to the safe option, which is usually no parole. AI doesn't get hungry. It doesn't get tired. It doesn't have a bad day because its football team lost. In that sense, AI can promote formal rationality. It treats everyone the same mechanically.
So it solves the biological bias. And it's the same, but we always hit with AI.
The data bias. If the AI is trained on historical data and that history is racist or biased, the AI will be too. We have the example of the Compass risk assessment tool in the US.
This is the one used for bail and sentencing risk, right?
Yes. The data showed disparities between black and white defendants. The AI was flagging black defendants as high risk more often than white defendants who had similar records. Why? Because it learned from a system that had historically over-policed certain communities.
So if you feed it racism, it eats racism and spits out racism.
And the danger is it spits it out under the guise of math. When a human is racist, we can call it out. When a computer gives a score of 9 out of 10 risk, we tend to think it's objective. It bakes the bias into the system permanently.
That's terrifying.
Yeah.
But then you look at China, and they are using these systems to fight misconduct. The sources mention the iron cage of data.
Yes, in China, the framing is very different. The systems are explicitly used to strengthen oversight of judges. Remember the 206 system requiring evidence checklists?
Right.
By digitizing every step, it creates an iron cage, a concept from sociology. It becomes much harder for a judge to arbitrarily ignore evidence or make a corrupt ruling because the system won't let them proceed without checking the box.
So it's using AI as a surveillance tool on the judges.
Exactly. It creates an audit trail that makes corruption harder. So you have this tension. AI can enforce fairness by stopping corrupt or lazy judges, but it can also enforce unfairness by replicating historical bias or removing discretion.
And how do the judges feel about all this? Are they welcoming their new robot overlords?
Not exactly. There was a study of 381 judges mentioned in our sources. It revealed deep skepticism. 64% had a negative sentiment. They did not believe AI would remove bias.
They didn't buy the objective math argument.
No. Their fear is the loss of humanity and justice. They talk about the need for a voice for the defendant. A computer processes data points. It doesn't listen to a person's story. And interestingly, the study found that judges with an internal locus of control, judges who believe in their own agency and ability, are more resistant. They don't want to be managed by an algorithm.
And in the U.S., the perspective is even more specific. Judges are being told they have to be gatekeepers.
Right. With the rise of deepfakes, the judge now has to understand technology well enough to rule on whether a piece of video evidence is real or AI generated. They are the last line of defense against AI manipulating the trial itself.
That leads us perfectly into adopting AI in common law jurisdictions. We've talked a lot about China and Brazil, which are civil law systems largely. How does this play out in the US, UK, Australia, India?
The distinction between common law and civil law is vital here. Common law, like in the US, UK, India, relies heavily on reasoned decisions and precedent.
So you have to explain why you decided something. You can't just check a box.
Exactly. You have to show your work. And that creates the black box problem with AI.
The black box.
If an AI uses a deep neural network to say guilty, it can't explain why it reached that conclusion. It's just a massive web of weights and biases inside the code. If a judge uses that, it clashes with the fundamental right to a fair trial. You have a right to know the reasoning used against you so you can appeal it.
So you can't just say the computer said so.
You absolutely cannot. That is why in common law jurisdictions, the adoption is different. In India, for example, they have a tool called Supace.
Supace.
Yes, and it is explicitly framed as a smart assistant, not a decision maker. It sifts files, it finds facts, it organizes the data, but the judgment is 100% human. The emphasis is on constitutional safeguards.
And in the U.S.?
The focus is on e-discovery, sorting documents before trial, and risk assessment for bail, as we discussed. But even there is high concern for due process.
And Australia?
Augmented intelligence. Again, the language matters. Not artificial intelligence replacing the human, but augmented intelligence helping the human. In Victoria, they talk about AI helping judges summarize competing contentions.
So across the board in common law, there's this human-in-the-loop mandate.
Rigidly so. The EU AI Act is the same. AI cannot be the final arbiter, but there is a glimpse of the future in a fascinating study called Agents Bench.
Agents Bench. Sounds like a fantasy football team for lawyers.
It's a simulation. Researchers used large language models to create a judicial panel. Imagine asking an AI to simulate a jury room. One AI agent plays the judge, others play jurors or lawyers. They debate the case.
The AIs talk to each other.
Yes. And because they are talking, they are generating text. The study attempts to create transparency by showing the reasoning process of these agents as they argue.
So instead of a black box giving an answer, you get a transcript of the AI debating itself.
Basically, it's an attempt to solve the why problem. If we can see the agents arguing the pros and cons, maybe we can trust the outcome more. It's still experimental, but it suggests a future where AI doesn't just decide, it deliberates.
Wow. Okay, we have covered a staggering amount of ground here today. We've gone from the political motivations of the left versus right to the backlog in Brazil, to the procedural auditing in Shanghai, to the front door chatbots in Australia.
It's a global transformation. It is reshaping the third branch of government.
So let's synthesize this. What does it all mean for you listening right now?
I think it comes down to a fundamental trade-off. We are using AI to do the heavy lifting, that's the efficiency. We are using it to enforce consistency, that's the deviation analysis. And we are using it to open doors for the public with access. But the trade-off is between speed and subjectivity.
We get faster justice, but maybe we lose the human element.
We risk losing the mercy, the nuance, the ability to look at a rule and say, yes, that's the rule, but in this specific case, it would be wrong to apply it.
And that brings me to the provocative final thought I want to leave everyone with. You mentioned Ctrl-AX earlier and the danger of stagnation.
Yes. Consider the concept of legal certainty versus stagnation. We all want the law to be predictable. We want to know that if we do X, the result is Y. But if AI ensures we always rule the way we ruled in the past, do we lose the ability of the law to evolve?
Are we building a system that perfects the past but prevents the future?
That's the danger. If we had this AI in 1900, would we ever have gotten the civil rights advancements of the 20th century? Or would the machine have just kept flagging deviation every time a judge tried to rule against segregation?
And think about that deviation analysis warning screen. If you were standing in front of a judge, hoping for a second chance, hoping for them to see you as a person and not a statistic, would you want that judge to see a flashing red warning light on their screen just because they wanted to show you mercy?
It's a chilling thought. It forces us to ask what we actually want from justice. Perfect consistency or human understanding.
It does. Thank you for guiding us through this deep dive. This was intense.
My pleasure. It's a conversation we need to have.
And to you, the listener, thanks for tuning in. This deep dive was custom built for you. We'll get you on the next one.